In this installment, Melissa McBain is being interviewed by Paul Hancock, discussing a landlord security when a tenant goes bankrupt.
Hey Melissa, what options are available to commercial landlords seeking to secure a tenant's performance of lease obligations?
Hey Paul, actually we're asked about this all the time. There are 3 general categories of security. 1, funds held as deposits, which can be security deposits or prepaid rent deposits, and yes, there's a difference. 2, letters of credit issued by a bank that a landlord can draw upon if the tenant defaults. And 3, third-party indemnity agreements.
So, what's the difference between a prepaid rent deposit and a security deposit?
Security deposits are funds given to the landlord to secure performance of the tenant's lease obligations. The landlord holds that money in trust, and the tenant retains an interest in those funds. The security deposit only becomes the property of the landlord when the landlord applies the deposit to satisfy a default under the lease. As the name implies, prepaid rent deposits are prepayments of rent to the landlord. These deposits become the property of the landlord upon payment, and the tenant doesn't retain an interest in the funds.
What's the significance of the deposit remaining as the tenant's property as opposed to the landlord's property?
Great question. The significance is that, depending on the characterization of the deposit, a landlord may lose its entitlement to a deposit in the context of a tenant bankruptcy or the disclaimer, aka termination, of the lease by the trustee in bankruptcy.
Yikes! Tell me more about that.
Yikes is right. Since a security deposit remains the property of the tenant, on bankruptcy, those funds form part of the bankrupt tenant's estate and belong to the tenant in bankruptcy. As a result, a prior ranking secured creditor will be entitled to the security deposit ahead of the landlord. This is one of the reasons it's so important for the landlord to promptly apply security deposits when there is a default. Use it or lose it.
Are you saying that prepaid rent deposits are a safer avenue for landlords?
Not quite. A tenant, or a trustee, could argue that a landlord has no legal basis to retain prepaid rent paid by the tenant for periods following the disclaimer of a lease. Since a disclaimer by the trustee has the same effect on the tenant as a consensual termination, the landlord likely has no legal basis to retain rent paid by the tenant for periods following the disclaimer, because the tenant has no obligation to pay rent for any portion of the term following the disclaimer. So if the tenant goes bankrupt and the lease is disclaimed, and there are no arrears, the landlord may have to forfeit to the trustee the prepaid rent for the post-disclaimer period.
Okay. Do landlords have any greater security in bankruptcy by looking to third-party indemnity agreements or letters of credit issued by banks?
Yes, they do. Courts have held that the liability of a third-party indemnifier remains intact despite the disclaimer of the lease by a trustee. However, a landlord should keep in mind that 1, the enforcement of an indemnity might require a court action to establish damages due to the landlord's duty to mitigate, and 2, there's always the possibility that an indemnifier could actually have inadequate assets for the landlord to realize upon, or they could become bankrupt or file for insolvency protection themselves. Under a properly drafted lease clause, an irrevocable standby letter of credit may be the most resilient to a tenant's bankruptcy because it entitles the landlord to draw on the letter of credit without requiring the landlord to prove its damages. The bank's obligation to honor the letter of credit is independent of the lease and independent of any disclaimer of the lease.
I'm sure we've only skimmed the surface on this, but high level, is it safe to say that a landlord security is better with a letter?
Yes, Paul. It's better with a letter.
That was Melissa McBain in conversation with Paul Hancock, discussing a landlord security when a tenant goes bankrupt. If you would like to learn more, contact Melissa on our website, dv-law.com.
This audio recording was a general discussion and should not be relied upon as legal advice.